The following BLTV program is brought to you by O'Flaherty Law. Please enjoy.
A Wisconsin attorney with O'Flaherty Law, and today I'd like to do a how-to video on how to fill out Probate Form 1801, the application for informal administration of an estate of a decedent. So we have the form up on the screen, and if you just move to the top of the page, you'll see it says State of Wisconsin Circuit Court, and then it gives you an option for county. Typically, you would enter the county that the decedent was living in when they passed away. That's the county that you would file this in. However, if the decedent lived outside of the state but owned property in the state of Wisconsin, you would file this application in whatever county the decedent owned property in. Moving on to the caption, it will say in the matter of the estate of, and you just put decedent's name and local address if you have one. There's a spot for the case number. The case number will be provided by the clerk of courts when you file your application for informal administration. If at some point you need to amend your application and file a second time, you would use the case number that was assigned to you when you filed your first application. You'll see a white square up to the top right-hand corner of the form. Don't put anything there. That is for the clerk of courts, and that is where they will file stamp the application when you file it with the clerk. Moving on to the first big section, you'll notice it says something kind of different up here. It says under oath I state. So this is going to be a sworn document, and it will have to be signed in front of a notary. In other words, this is like an affidavit. You are making these statements under oath. We'll start with paragraph number 1, which just identifies the decedent. It asks for date of birth. It asks for date of death. It asks where the decedent lived, which could or might not be within the state of Wisconsin, and what their mailing address is. On line 2, you will list who you are and why you're interested. Whether you are a surviving spouse or child of the deceased, you need to state who you are and what your relationship is and why you're interested in it. In paragraph 3, the court wants to know if there are other proceedings concerning the decedent's estate. If they exist, if they're pending in the state of Wisconsin or elsewhere. It gives you a pretty short line to explain. So what you probably want to do is, if there's more than one small thing to include there, you should go ahead and put it on a separate sheet of paper and then just put see attached and attach the sheet of paper to the application when you file it. If there's nothing, just don't put anything. Paragraph 4 deals with the net value of the decedent's property. If the net value of the property is under $50,000, it qualifies for informal administration in Wisconsin. If it's above $50,000, it does have to go through formal probate. Paragraph number 5 asks about what state aid the decedent received. It has a few options here. It's possible that if the decedent was very sick prior to passing away, that they would have received all of these benefits. So it would be helpful if prior to sitting down with the application, you looked into what medical care the decedent received from the state prior to death. If the decedent received medical care from the state prior to death and you didn't put that in the informal administration application, remember it is under oath, and you are expected to have this information. Additionally, the reason why the application asks for this information is that it may be the estate may need to reimburse the aid that the decedent received. The final option here is the decedent was or was not a patient or inmate at a state or county hospital or institution, or responsible for any person owing an obligation to the state or county. They give you some room to explain things here, and as above, if you need more than one short line to explain, you can put it on a separate sheet of paper, identify it on this line, and attach it to the application before you file it. If you don't know, or if you can't find out, then that's okay. You just need to say that you don't know. Typically, they'll run a check and find out if the decedent received any aid. Paragraph 6 wants to know if the decedent was ever married. If there was more than one spouse, you're going to need a few extra pages. They want to know if the spouse is living or deceased. They want to know if the decedent was married at the time of death or if they were divorced. And they want to know if the spouse received any state aid again. Fortunately, because that information can be a little difficult to get if the person themselves has passed away or if they just won't communicate with you, you can tell the state that you lack the information necessary to complete this section. So here we have a bar that highlights questions 7 or 8 on the application. And it instructs you to complete questions 7 or 8 below, whichever is applicable. So question 7 asks whether or not the decedent passed away with a will and any will codicils. Ideally, if you are applying for informal administration, you will have this information handy. You can have an estate informally administered even if a will exists, but you just need to share that information with the court. If the will specifically says that the estate cannot be informally administered, then you're not going to be able to do the informal administration. If a will exists, the court wants information on authenticating the validity of the will. And that's why lower down in question number 7, it asks you to say, I believe these documents were executed properly and are valid. I made diligent inquiry, and I am unaware of any revocation by decedent. So what they want to know is if the will would survive, say, a will challenge, if the will was properly formed, if the will was properly witnessed, all of those types of things that would make the will valid and enforceable in the probate court. And there could be a will and there could be codicils to the will, but there could also be a revocation of the will. So you want to make sure when you're going through paperwork or reviewing documents that if there's a will and a codicil or codicils, that there's no revocation either in that file. They want you to check through these elements. The original will, including any codicils, is in possession of the court, accompanies this application, was probated elsewhere, and an authenticated copy accompanies this application. This would be for if the person was domiciled outside the state of Wisconsin, and this informal application is probably just for, say, a piece of real estate that the decedent owned inside the state of Wisconsin. And they also ask if it's not accompanying the application, is it en route to court by mail or personal delivery? Next, question 7 asks, the personal representatives named by the decedent in the will or in any codicil is, and you have to list them. You can also nominate someone to serve as a personal representative. If there are any trustees named by the decedent in the will, if you want to nominate anyone to serve as a trustee, if that's necessary. So that is a pretty big section of the application is question 7. And it just has to be filled out if there's a will and any codicils. Question number 8 is a little bit easier. It just asks you if you made a diligent inquiry, if you conducted a reasonable search, and that you are unaware of any unrevoked will of the decedent and believe that the decedent died leaving no will. And then you nominate someone to serve as the personal representative. Now, typically this is the person filling out and filing the application for informal administration. Once you've gotten through questions 7 and 8, you have to fill out question 9. And again, they don't give you a lot of room in these sections. If there's more than one really interested party, could be an heir, beneficiary, or fiduciary. So I suggest, again, putting it on a separate sheet of paper, clicking See Attached, and having the list there. Now, they give you a description of who the interested persons could be. For any person with disabilities, also list any guardian of the estate. For any person in the military, also list attorney or attorney-in-fact, and for any minor, list date of birth. So this could conceivably be a fairly long list of people, especially if the family was larger, or if people are serving in the military, or if there are, for instance, many grandchildren and great-grandchildren involved. 10 just says Other. There might be a special request that you want to make. This is sort of a catch-all on the informal application. If you click it and then fill out an explanation of something you're asking to be done or some special request of the court, this would be the place to put it. So you've made your statements of basic information under oath, and then we get to the portion where you request from the court. Here's your request. You're requesting 1, that a statement of informal administration be issued. 2, that the will, if it exists, including any codicils to that will, if they exist, be admitted to informal administration. That domiciliary letters be issued to whoever is required to receive one. You will see forms accompanying 1801 showing you what to put in domiciliary letters. The same for letters of trust, if a trust exists. A trust can be very small and you would still have to have it included in the informal administration. And there can be more than one trust, which is why they give you 2 spots. Once again, you get the little catch-all down here, Other. If there's some special action you would like the court to take, here's where you would put it in. Now remember that we discussed earlier in the video that you are filling out this application under oath. You can fill out almost the entire thing by yourself, but don't sign it. You would sign here in the right-hand signature block because you're the applicant, but you need to sign it in front of a notary. This portion here is what the notary will fill out when you sign it here in front of the notary. And typically, you can go to your bank and get a free notarization. If you have, for instance, you have accounts at JP Morgan Chase, you can make an appointment and go sign in front of them, and that's just part of being a member there. Otherwise, notaries aren't that expensive, and you can use remote notaries for these types of things because they understand that a lot of people who are dealing with these types of issues reside outside the state of Wisconsin. So again, you would sign in front of the notary, name printed and typed, your address, email address, telephone number, date of sign, and then you can have an attorney fill this out for you, and that's why they have a spot for the state bar number. Once again, as I've mentioned, this form doesn't give a lot of room for explanation, but you can't modify the form. You have to supplement it with a separate page. So whatever you do, do not change the form in any way. Just if you need, for instance, Like in number 9, more space, you would just click see attached and then fill out this information on a separate sheet of paper and include it with your petition when you file it. But please do not alter the form. And that is how you fill out an application for an informal administration of decedent's estate in Wisconsin. Thank you so much for watching. To learn more about estate planning and probate law, you can visit our page, which is linked below.
Hi again, this is Kevin O'Flaherty from O'Flaherty Law. I hope you enjoyed the video and podcast. If you did, I'd love it if you'd subscribe to our channel. If you need legal help in this or any other area of law, please don't hesitate to reach out to schedule a consultation. Most consultations are free and can be conducted remotely if you'd like. You can email us, book online, or call us at 414-253-2080. That's 414-253-2080. We have many locations for your convenience and we serve all of Wisconsin. Thanks again for watching.